They want to kill my client. That's what we're playing with, his wife, Judge.
Stop, wait. You just told me this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Ms. Bradley's testimony in the murder case is wholly irrelevant, so.
They want life in
We're
prison.
talking about the tampering case, or we're talking about the?
We are talking about the tampering,
Okay.
but they're also intermingled with each other. So it's life in prison for this
Okay, I got it.
tampering.
A motions hearing for many true crime watchers sometimes can be a snooze fest, but not this YNW Melly hearing.
So what has happened in the past is that she has asked for dates, we provide dates, and then she schedules dates or times outside of those.
Judge, he's
And
actually
then-
lying to the court right now. I've printed out every email.
Please, stop.
The judge overseeing YNW Melly's retrial is telling the state to hurry up and move the case forward.
So in case I'm not making my feelings on this point clear, I'm not prejudging anything, but talking to a judge about trying to agree to set depots in a death penalty case is absurd. And I'm embarrassed for both sides. I'm embarrassed.
But the true fireworks came from Melly's lead defense attorney.
And now, 2 years later, I'm being accused of trying to kill Danny Fuller. I don't know exactly because we don't know the affidavits, but it's a homicide detective and it's Danny Fuller's picture, and I'm directing gang activity. I think at this point, Mr. Detective Fuller is in need of an evaluation to determine if he even has the capacity to.
Jamel Dimmons, aka YNW Melly, has been locked up in jail for 6 years, despite not being convicted of a crime. I'm Elizabeth Millner for Law&Crime. As you just heard, the judge in Melly's case says he's embarrassed for both the prosecution and the defense. Plus, you might be wondering, why is Melly's attorney saying a detective needs a mental evaluation? So let's unpack it all, and it's a lot. During this week's court hearing, Melly didn't appear in the best spirits for another motions hearing. He's been locked up since February of 2019, 6 years now, despite not being convicted of a crime. At this point, we all know he was tried, but his first trial ended in a mistrial. That was in 2023. Since his trial has been pushed back and back and back, but he's expected to be retried in September of this year. While both sides are prepping for his highly anticipated retrial, they still continue to hammer out motions, mainly from the defense's side.
There's 8 motions. Number 1, defendant's motion for order to show cause to the state of Florida's ongoing willful and flagrant violation of court dated February 9, 2024. 2, motion in limine to exclude James Howard to relevant and immaterial detention communication calls. 3, motion in limine to exclude a relevant and immaterial TikTok video of meat debate. 4, renewed motion to take deposition of Christine Bradley. 5, defendant's motion to strike from the alternative response to the state of Florida's motion to allow former testimony of Felicia Holmes. 6, motion for scheduling order. 7, amended third motion to compel forensic images of proceedings following. And 8, motion to compel. So that's what I wanted to get done today.
So here's the thing. The defense was ready to argue their motions, but the drama started when the state said they didn't meet their deadline, and Melly's lead attorney, Raven Liberty, wasn't having it.
Judge, the other issue we have, and I wasn't present for the hearing Friday afternoon, but my understanding was the court set a notice of hearing deadline for Friday 5 p.m. It was moved to Friday 9 p.m. because Ms. Liberty was stuck in court and needed time to prepare it. The notice was not actually filed until Saturday, so they failed to comply with the court's requirements. So at this point, the state's position is no notice of hearing was properly filed and there's nothing to be heard today.
Okay. So you want me to do anything?
This also in light of the fact that Ms. Buckle is unavailable.
Okay.
Mayor,
Ms. Liberty, what do you want me to do?
the funny thing is, the great thing about those cameras in this room is everything is recorded. I did say Friday at 9, and then I actually stepped back because I knew I was setting myself up for failure. And I said, well, I do it Saturday. Taylor didn't respond to Ms. Collins. Oh, as long as we get it before the beginning of the next business day, which is Monday. So they had it. Most of these motions, Judge, were filed for over a year. I will bring the court's attention because last night in preparation of this, I know the last time we were before, they objected then about hearing motions because they were filed under the tampering case. Yet they filed several different motions saying it doesn't matter what case number are on the motions because the discovery is interchangeable. I'm quoting exactly the language from their own motion. So it's good for them when it's convenient, and now it's not convenient, so there's another excuse. It's been a year. Everything was properly noticed. I will also add, there's no written order setting a filing deadline or allowing them to file a response within a certain time frame, that was oral. So as we all know, oral orders don't count for anything. They need to be written. There was no written order. I did ask to extend it. We are ready to go forward. There are 2 state attorneys sitting over there. Understandable. One of them's missing. Mr. Griffiths, is there something funny?
The lead attorney is missing.
Ms. Liberty, you can direct your comments to me.
Okay.
All right, y'all
So
have
we're
5
ready.
years to talk to each other about things.
We're ready
You
to
just
go
talk
for a
me.
judge.
Okay.
The first motion was pushed to another hearing for more time. The second one had to deal with Melly's witness tampering charge. So back in the fall of 2023, after Melly's first trial ended in a mistrial, Broward County Detective Danny Polo, who also testified in his first trial, was investigating a blood member held at the jail. But what does that have to do with Melly? Well, Detective Polo was monitoring that reported blood member James Howard's recorded phone calls and heard him talking about passing messages to Melly. Then Detective Polo later uncovered hundreds of phone calls between James Howard, Melly's ex-girlfriend Mariah, Melly's manager, Jamison Francois, and Melly's co-defendant, Cortland Henry. Now, the state wants those phone calls to be admitted for retrial, and it's kind of clear why the defense doesn't.
Number 2 is defendant Jamel Demon's motion in limine to exclude James Howard's irrelevant and immaterial detention communications. So you're talking about, this is a motion in limine for trial. And I read the motion. Anything else you want to tell me in support of your motion, Felicity?
This judge, it was close to, I want to say 84 hours worth of phone calls that were given to us that December. We were set for trial. I was always of the position it was given to us that late in the game in order to make us continue it. Nonetheless, I had a group of students go through those phone calls along with myself and the investigator. When you look at the police report that was authored by Garrett Steele, starts referencing a investigation that's being done by Danny Polo into this James Howard, and I believe the Alden game. He, for some reason, then references James Howard in this police report, saying he was listening to phone calls by James Howard, and then he hears James Howard telling somebody on the phone call that he has to do something for Melly that day. We had the opportunity to depose Detective Polo as well. I asked him this very question. I told him over 80 hours worth of phone calls. There was one phone call, and that one phone call in this batch of phone calls tells us nothing other than him saying, oh, I have to talk to Melly today. Not I have to do something for him, not I got to call people for him, nothing at all. During the deposition of Detective Polo, when I started questioning him, hey, I went through all these phone calls, could you please direct me to what phone call I should be looking at? What batch of phone calls? He then tells me, it's not this batch of phone calls. It's a batch of phone calls that would go back to 2020 and 2021. We are dealing with the tampering, I believe we're spanning from April of 2023 until August of 2023, somewhere in that time frame. Detective Polo, in his own words, was the only time that he had heard James Howard talking about Melly, would have predated the incident, i.e. 2020, 2021. Nonetheless, those phone calls are not in this 84 hours of phone calls.
Dave, can you respond?
Judge, before we proceed on that, there is still the outstanding issue whether Mr. Demon still wants Ms. Liberty representing him. The state has raised the issue of the conflict of interest. The court has pointed that out. That was going to be one of the first things we were going to address today, and we still need to address that because obviously if he does not want Ms. Liberty representing him, then there's an issue to issues that you have to argue.
I mean, that's his call. I already had that discussion. So I'm sure if there's something that you want to let me know, you're going to let me know.
If you're wondering about that exchange, last month it was revealed Raven Liberty was under investigation for allegations of witness tampering too. More on that in a few, but let's get back to the motion.
Any response to the motion?
Yes, Judge. State filed a written response. I believe it was yesterday. This is one that Ms. Buckaloo prepared, but as pointed out in the argument, that the state is not required to disclose which calls it intends to use at trial. But other than that, we are going to rely on the response that's written.
So I did check the docket this morning. I saw no written motion. And it's funny, Judge, that they were starting this hearing off saying they wanted to continue it because they didn't get proper notice a notice of hearing from, I don't know, almost 2 weeks ago. But in the evening, they filed something before Ms. Buckley went to the hospital.
Ms. Liberty, this is the second time. You need to look at me and address things to me, okay?
Sorry, Judge.
I could give you a lot of adjectives about what I think of this entire procedure. Funny's not going to be one.
Okay.
So,
My
anything else you want
apologies.
to tell me about this?
No, Judge, I would
Okay.
say there are no material phone calls that would even go to the nexus of witness tampering.
Okay, so this one, and I'll enter the appropriate order, is going to be denied without prejudice. I have no idea of what is or what is not going to be relevant. And without hearing the evidence at trial, there's no way that I could. I can't make the state try their case in a vacuum. But without prejudice, you can certainly raise the issue if the state tries to introduce any of these phone calls at trial. Give the appropriate objection, and I'll give you the appropriate ruling. But in a vacuum, having never heard any of these calls, I have no idea what the calls are, nor do I have any idea what the evidence is going to be at the trial. So that one's going to be denied without prejudice.
A familiar name was brought up in one of the following motions.
Number 4, renewed motion to take the deposition of Christine Bradley. I did read the motion. Anything else you want to tell me, please?
I would just say Judge Murphy had already entered that order, which I attached December 18th. And it says, after such emails are reviewed, if defense still wishes to depose ASA Bradley, counsel shall file a written motion.
If you've been following this case closely, you know who Christine Bradley is. She was the lead prosecutor in Melly's first trial, but she was thrown off the case months after Melly's mistrial. Why? Well, it's a long story, but to make it quick, another Broward County State Attorney, Michelle Boudreaux, came forward and testified she overheard the lead investigator, Mark Moretti, ask a deputy to lie about being present during a search warrant for Melly's mom's phone back in October of 2022, months before his first trial. That information wasn't turned over to the defense until after his mistrial. Now, Christine Bradley fits into all of this because she said the exchange was a joke, but ultimately Judge Murphy, who oversaw Melly's first trial, yanked her off the case out of an abundance of caution because the defense might use her as a witness in Melly's retrial to discredit lead investigator Mark Moretti. Now, fast forward nearly 2 years later, the defense wants to depose her.
So I did that, I think sometime in February, close to a year ago. I wrote it out. At this point, we need to depose her, especially in light of all the things that have came up. I went through and I amended this motion to add a few other things that had happened in the deposition, i.e. these emails. They get even more confusing. Your lead detective on this case, Garrett Steele, said under oath that he never read these emails. These emails are referenced throughout the affidavit and the arrest, stating that the deposition and these emails prove there was an official proceeding that Mariah Hamilton did not go to. Again, Garrett Steele said he never read the emails. Danny Polo then says it's not his case and he can't comment on the emails. It's really unclear from reading them what's happening. And again, there were certain emails that were not even provided by the state that we later were given from other sources.
Okay, state your response.
First, that's an inaccurate statement. The emails were actually provided. That's actually in the state's response to one of Ms. Liberty's other motions, but turning specifically to this one, state filed a response back on January 2nd of 2024, and we're relying on that response.
So Judge, the rules provide I can take depositions of anybody with relevant information, which Ms. Bradley is, whether she's listed
I agree.
or not
we
listed.
need-
Because they filed a protective order and won't allow me to do it. That's why I had to then file the first motion.
All right, so Mr. Gribbs, I'm looking at 3.220 subsection H, discovery depositions, and this is 1A. The defendant may, without leave of court, take the deposition of any witness listed by a prosecutor as a Category A witness or listed by a co-defendant as a witness to be called at a joint trial hearing. That's not Ms. Bradley in this case. Yes.
Correct.
But then the next sentence says, after receipt by the defendant of the discovery exhibit, the defendant may, again, without leave of court, take the deposition of any unlisted witness who may have information relevant to the offense charged. So don't they get to take her deposition?
Except for the fact that, Judge, she is a state attorney. In her role as state attorney, she is entitled to certain protections. We filed a protective order, in part because everything that Ms. Liberty is asking for has been turned over. The emails, whatever else that she's been looking for, has been turned over, I believe actually several times by Ms. Buckaloo, again, which is one of the issues going forward today, not having her here. But she was the one that provided copies of everything.
Well, she's not assistant state attorney assigned to this case.
Ms. Bradley? No, but she's still,
What's the problem?
it's no different than if somebody is a case filer or works on a case. There are work product protections involved in terms of what Ms. Liberty intends to ask. And we sought that protective order because she's entitled to those protections as a prosecutor, and also because, based upon our response, that it is unnecessary. I'm sorry.
Did someone grant the protective order?
I believe that was a hearing that Mr. Klinger conducted back in like November of last year, but I was not party to that.
So that's where we get this order coming down on December 18th. And then Ms. Buckley was ordered to provide emails, and if I was not satisfied, as that order clearly states, write the motion so I could depose her. So I've written the motion. I am looking at what she provided.
I guess that's where, Ms. Liberty, I'm still not following what the relevance is. Tell me what, let's say she wrote 1,000 emails back and forth between the witnesses. What is the relevance?
Because if you go to the arrest affidavit, under the witness tampering, these emails that Ms. Bradley authored are specifically referenced in Garrett Steele's police report, right? He says that he reviewed emails between Christine Bradley and defense counsel coordinating the deposition of Mariah Hamilton, that she showed her numerous attempts to get Mariah Hamilton to this deposition. That is Garrett Steele's words. We deposed him. I put in the motion. Garrett Steele then says, I never read a single email. I'm depending on him.
His report's not going to be in front of the jury. I mean, none of that's going to be in front of the jury.
I know, Judge, but when I'm moving to set up every element of this witness tampering case, that seems more and more that it was filed out of being vindictive, more so than anything else. It is relevant to these emails because it is part and parcel of everything of the basis of arresting Mr. Demmons. They weren't saying Mariah Hamilton didn't show up to trial. They said Mariah Hamilton didn't show up to a deposition. The other reason I need to depose Christine Bradley, because it's really important how that May 5th date was given, all right? So when we're trying to go with the premise that my client tampered with Mariah Hamilton because she didn't go up to this deposition, we need to hear from Christine Bradley and find out what efforts she made to coordinate this deposition with Christopher Barris. That is why she was also supposed to turn over these emails. And guess what? When you read these emails that get turned over, Stuart Adelstein's emailing with Miss Bradley, trying to ask for dates for the deposition. There was not one single email that was provided to us in Ms. Buckley's response from the time that Christine Bradley gives us dates to the time that Stuart takes them. She was not contacting Mr. Barris. We can't see that at all from her emails. We finally get an email from her April 18th that's copying an email from April 17th. That appears to be the first email that she sent to Christopher Barris about this deposition. So for the state to not coordinate a deposition with a witness and then to cover up their negligence, turn around and file a criminal charge against the defendant, when in reality, if we got her up there, we would hear from Miss Bradley that she never properly coordinated this deposition, that she never told Christopher Barris. And all the months leading up to us trying to schedule this, Mr. Barris, from these emails, was never contacted. And that's what we need to depose her about, the efforts that were made from her.
The judge's ruling was another blow to the defense. Well, depends on how you look at it.
They want to kill my client. That's what we're playing with, his life.
Stop, wait. You just told me this has to do with the tampering case. No one's getting the death penalty for the tampering case.
Yeah, but they want
Ms.
like...
Bradley's testimony in the murder case is wholly irrelevant, so.
They want
Let's go
life in
back. Are we
prison.
talking about the tampering case, or are we talking about the
We are talking
homicide
about the
case?
tampering, but they're also intermingled with each other. So it's life in prison.
Okay, I got it. Respectfully, over the defense objection, the renewed motion to take the deposition of Christian Travis and deny it. So I'll get in the appropriate written order. I don't find that her testimony would be relevant in any way, shape, or form. It's not relevant in a homicide case, nor do I find that it's necessary under what's been followed in the tampering case with information or what's required to be proven pursuant to the jury instructions. But you're telling me you listed her as a witness, that means you have a good faith belief that you're going to call her as a witness, so you can call her as a witness. Ask whatever questions you want from the jury under oath, but that one's going to be denied.
Now, remember how I mentioned Melly's been locked up for 6 years, not even convicted? Well, the judge is pushing prosecutors to move the case forward, essentially hurry up.
I consider this more of a professional courtesy. If the parties want to be courteous to each other, that's always kind of preferred, I guess. But if the parties don't want to be courteous to each other, you don't have to wait for one state attorney to tell you. Set the deadline.
Okay.
Mr. Devins has now been in custody for 2,202 days, okay? And if one state attorney is not available, maybe one of the other two assigned to this case can stand in. And if all three are not available, maybe one of the other 150 state attorneys upstairs might be able to sit in, but you don't have to wait on them. So.
Thank you so much, Judge.
I mean,
just so you're clear, you're not advising Ms. Liberty to unilaterally set the motion. She's
no, it's
still
not unilateral. She can
still
coordinate.
coordinate with us.
If I'm getting, I read the motion. She says she's, I have one state attorney who you're telling me is working 1 day a week here. Is that right? So that's 80% of the time is off the table, and just being told that they can't show up to these depots and won't do it. You don't have to wait. Set the depots, subpoena the witnesses, and if someone doesn't answer a subpoena, file the appropriate motion, and I'll conduct an indirect criminal contempt proceeding. But it's time to move forward.
We are moving forward, Judge, but we also, the other issue has been is that Ms. Liberty must properly coordinate and must properly notice the state. This is a recurring. I know, but
I just read the rule. She doesn't have to coordinate anything. She has to make a good faith effort.
Right, she has to make an effort.
She has to put a certificate on the bottom that says, I tried, they told me no.
So what has happened in the past is that she has asked for dates, we provide dates, and then she schedules dates out or times outside of those.
Judge, he's
And
actually
then-
lying to the board right now. I've printed out every
Please,
email.
please, stop. She's going to set her deadlines. She has to put a certificate of good faith in the bottom. If you all feel that that has been submitted
We'll file
in
for
error, you file the appropriate motion, and then what would be a wonderful use of this court's time is I'll have a hearing with 6 lawyers, 7 lawyers, because you all can't set that. So in case I'm not making my feelings on this point clear, I'm not prejudging anything, but talking to a judge about trying to agree to set depots in a death penalty case is absurd. And I'm embarrassed for both sides. I'm embarrassed. The motion for scheduling order is denied. You don't need a scheduling order. Set your depot. I'll enter the appropriate written order.
Yeah, that back and forth between the state and the defense definitely seems to be annoying the judge. Now, for motion number 7, the defense wanted the forensic images of the victims' phones.
I think the issue that Ms. Buckaloo had, and I'm probably going to be speaking out of turn on this one, is that there are contents of the phones that are not relevant to the case. And so some items have been turned over, but not all the items. But unfortunately, I am not, this is one where I am lacking of knowledge.
That's okay. The state doesn't get to decide what's relevant and what's not relevant. These are the homicide victims, right?
Yes.
Just turn over everything you have.
Well, Judge, I can tell you, because I took part of it, it's not necessarily that we have to turn it over, we have to make it available for inspection. We did on a number of dates, we
Okay.
scheduled that, we've told them they can come again. There were multiple days where we sat there and waited for their investigator, who came hours late.
She's
But
lying
we have-
again. So I'm going to.
If I may
So
finish,
there's-
Your
hold
Honor.
on.
I was the one who was personally there that day with him and our investigator. We continue. Anytime they want to come see it, we have had an investigator from our office, the computer, and their investigator there to sit down and go through it anytime they want.
Stick a thumb drive in and download what you got, and that's it?
Make a
Yes.
copy of it? No, Your Honor.
They're
Why
withholding
can't
it.
they do that?
As Mr. Griffith said, Ms. Buffalo is the one with the most knowledge of all the contents of the phone, and that's why it's all discussed in her response. But regardless, the state's obligation is to make it available. We have and continue to, anytime that they want to
But make it available-
schedule.
One of the things
for
to make it
inspection.
available for is to copy it. They're
If
allowed
it's
to
available
copy
to
it.
be copied. Ms. Bucklew, and that's why, again, this is one of the motions we said that she would be prepared to argue, is of the opinion, and she
You
filed
already
the
went to
whole.
trial. You already
Exactly,
went
right.
to trial?
And it was
Yeah.
You already went
withheld
to
then.
trial.
Yes,
This is the decedent's cell phones. Okay, over the state's objection, this motion is granted in full. Make the appointment, go over there, download everything that they have.
Now, the final few moments of this hearing finally gave us the answer as to why Melly's attorney, Raven Liberty, was under investigation by the Broward County Sheriff's Office, and her request to the judge was interesting, to say the least.
In light of these allegations that I'm, I guess, trying to murder or take a hit out on Danny Polo, it's came to my attention that Danny Polo might be suffering from some type of mental illness at this point. We heard in the last trial he thought somebody had a kid out on him. He had lied to the court. We found out he had pictures out there in the public domain. And now, 2 years later, I'm being accused of trying to kill Danny Polo. I don't know exactly, because we don't know the affidavits, but it's a homicide detective, and it's Danny Polo's picture, and I'm directing gang activity. I think at this point, Mr. Polo is in need of an evaluation to determine if he even has the capacity to sit and testify in this case or any other case, because he has some type of paranoia about being murdered at this point. That's where he's going at a defense attorney, saying a defense attorney is trying to murder him now. Because that is the premise of this so-called investigation, is I'm trying to kill Danny Polo. That's the witness that they're saying I'm tampering with, because he was impeached, not once but twice.
Okay, and the request
Is that he undergoes a psych evaluation before he's allowed to testify further in this case.
I think, because I don't entertain or attempt motions, but I think you're talking about challenging the competency of the witness, correct?
Oh, yes.
Okay, so I think if you have that concern, I guess you need to file the appropriate written motion regarding the competency of the witness, and then I will give you the.
Thank you, Judge.
It's a pretty strong ask, but it's also a strong allegation. Now, in Melly's first trial, Detective Danny Polo made headlines while donning a black ski mask while he testified as a witness for the state. Now, he works in gangs, undercover, and said he requested to wear the mask to protect his identity. Then a photo of him unmasked went viral. Melly's defense team wanted him to testify unmasked, and the previous judge, John Murphy, sided with the defense and ruled his testimony would continue without the mask. So it's unclear if Detective Danny Polo will be evaluated. And obviously, Raven Liberty denies the allegations. But for now, it looks like Melly plans to keep Raven Liberty on his team. YNW Melly's high-profile retrial is slated for September of this year. If he's convicted, he faces not only life in prison, but also the death penalty. Reporting for Law&Crime, I'm Elizabeth Millner.